Hello again. The Senzo Meyiwa murder trial has been marred by delays and drama inside and outside the courtroom. Today was no exception, with defense lawyer Malesela Teffo asking for a special application for a trial within a trial. Let's get some analysis now on today's proceedings and some of the highlights with legal expert Zola Majavu. Mr. Majavu, good afternoon and thank you very much for your time. Let's begin. I would like to begin where things ended today before we go back to Advocate Teffo, what happened with that application this morning. The cross-examination carried on very clearly. The defense lawyer, Advocate Mshololo, still poking holes, trying very hard to expose, according to the fact that the crime scene was allegedly contaminated, and secondly that forensic officer Thabo Musia didn't do a proper job. How do you see all of that, the way it played out?
I think she's onto, legally speaking, onto a good strategy, provided that she is hoping that the strength of the state's case is hinging on that which Sergeant Musia would have amassed during his initial handling of the crime scene. Obviously, if she were to successfully prove that the crime scene was contaminated, it may go some distance in discrediting the credibility of whatever evidence may have been tabled by Sergeant Musia. But it's also very dangerous because the assumption should not be that the high watermark of the state's case is exactly hinging on the contamination or otherwise of how Musia handled the crime scene. So to some degree, I can understand where she's going with this, but I think it's still early days, because at the end of the day, this case is going to be more about the direct evidence that seeks to point incriminating fingers to those who are before the dock.
Yeah, because for us as lay people, when we're listening to this, we're watching, we say, oh, the police must have missed that crucial evidence. Therefore, are they accused the right suspects or not to be in the dock? So it creates those kinds of questions in our minds.
Yes, she's trying to create doubt, obviously, that the theory must and can only be that those who are currently in the dock are not the right people to have been arraigned. Now, whether or not she will succeed in demonstrating that in the current line of cross-examination remains to be seen, but one can accept that the probative value which would be attached to Sergeant Musia's weight would be on a far more reduced a basis, and thanks to Advocate Mshololo, in fairness to her. But it's still early days. I think we have not even begun to scratch the surface in terms of what truly happened there. Remember, so far, no direct eyewitness has been called. So obviously, this case is still standing on a footing of circumstantial evidence. But I still think that it's still early days.
Yeah, still early days. Now, on the issue of this trial within a trial, the whole issue around confessions, as you told us last week, you don't discuss such until or unless prosecution has presented such confessions in court. But Advocate Teffo seems to be carrying on that line in terms of his application earlier today.
That application, as I said last week, was stillborn then, as it was stillborn today, because the triggering effect that would have caused a defense attorney on his feet had not yet been played out, because nobody knows. The judge certainly doesn't know. The defense doesn't know whether or not Advocate Baloyi, in the fullness of time, would even rely on a confession. He may decide not to rely on a confession, in which case that application would have been brought totally prematurely. But what is bizarre, and I say this with respect, about the timing of that application is this. It is brought by a person who himself had finished his cross-examination. This person then stands up and says, when a core defense counsel has just begun their own cross-examination, stop your cross-examination, because it is an exercise in futility. But He does not know what instructions Advocate Mshololo holds on behalf of accused number 5, firstly. Secondly, it is unprecedented, it is unheard of, and it is certainly something that you do not do in the middle of a cross-examination on behalf of a client on whose behalf you are not acting, firstly. Secondly, the judge is right. There is no confession before him. There's not even an indication that a confession might be relied upon. And it's not only a confession, by the way, it's a confession and some pointing outs. Those will become relevant if and when the state, through Advocate Baloyi, decides that he wants to tender that material into evidence. Only then would the issue of a trial within a trial arise. And even if it were to arise, it is not a given conclusion that the presiding officer may rule that that is the way to go, except to state that the best way of determining the admissibility of any evidential material, confessions, admissions, pointings out, is done through a trial within a trial. So that application had neither force nor merit right from the onset, and I'm not surprised that the judge ruled the way he did. And also, the judge has got no legal wherewithal to decide to discontinue a prosecution. Remember, all 5 witnesses have already pleaded. The only person who is vested with the authority to discontinue the prosecution would be the state prosecutor. And if he decides to discontinue the prosecution, because the accused persons have already pleaded, chances are the charges cannot be competently withdrawn. A not guilty verdict would then have to follow if the evidence currently before the judge does not prove to a guilt beyond reasonable doubt. So it was quite premature, and I would be very surprised if Advocate Baloyi persists with tendering a confession as evidence. Of course, viewers out there may not appreciate this. Advocate Mshololo as well as Advocate Teffo are sitting with the full docket, meaning all the witnesses' names, all the witnesses' statements. So as defense, they know what each and every single witness, when they are on their feet, is going to say. It does not mean out of a list of 130 witnesses that they may have been provided with statements of, the state is going to call all of them. The state may call 5, they may call 2, or they may rest their case on a confession if it is found to be admissible. So it was really of no moment to bring that application. And quite frankly, it was a waste of Advocate Mshololo's time. But I respect that Advocate Teffo is acting on instructions. He had to do what he had to do. But that application was dismissed, and rightly so.
Yeah, very odd way of getting along, of approaching it from his side, as you've just explained. Now, finally, before I let you go, Mr. Majavu, the cross-examination of this first witness of the state, being Forensic Officer Thabo Mosia, has sort of been toing and froing because of the sideshows, as you called them last week here when we were analyzing this trial so far. After Advocate Mshololo is done, because Advocate Teffo is done, he should be off the stand now. Then we should be moving to the next witnesses, whoever the state might choose to call.
Not quite. It may well be, and I suspect that this is what is probably going to happen, knowing Advocate Baloyi. He has an opportunity to do what is called a re-examination. This is basically a second bite that he may have with his own witness being Sergeant Mosia. It normally has to do with questions that he may be of the view that Sergeant Mosia did not quite answer correctly, or he might need to mop up some shoddiness in terms of the responses. It is certainly not an opportunity to ask questions that he could have asked originally when he led him. So we can expect, and I'll bet my bottom rand on it, we can expect that when Advocate Mshololo is done, Advocate Baloyi, who is a state prosecutor, is going to stand up and ask a few questions. And you will see how those questions are phrased. They will be aimed at making sure that where Sergeant Mosia might not have come smart, he gets a second opportunity to re-clarify some of his answers. And it is very a useful tool that any person who leads a witness in chief utilizes. You don't let go of that opportunity, because Sergeant Musia has not covered himself in glory in some of the ways in which he responded. But it does not mean everything else that he said should be thrown out of the window. It's a balancing exercise that a judge would have to do. You can almost accept that there will be a re-examination by Advocate Baloyi. Once that has happened, then the state will move to the next witness, and that Advocate Baloyi would announce on the day, but collegially he can also notify his colleagues the day before to say, on your list of witnesses, I intend calling this particular witness, to enable the defense counsels to go through their dockets and familiarize themselves with the statements of that particular witness who is going to be called. There's no element of surprise. If anyone has the element of surprise, it is the defense, because the defense is under no legal obligation to tell the state, one, who they intend to call, two, what those people are going to say, which is why I was quite surprised when a defense volunteers that they are going to call a particular witness, and this is the detail to which this particular witness would be testifying, when the witness to whom a version is put has said nothing, absolutely nothing that directly implicates your clients. But we employ different strategies as lawyers, and I respect my colleagues fully. But yes, only after Advocate Mshololo is done, Advocate Baloyi will re-examine if he so chooses, and only then will the next witness be called. And we'll follow the same process. He'll testify in chief and be cross-examined.
And that second bite at the cherry by the prosecutor, you said you bet your bottom dollar on it. We'll have to wait and see then. So as far as we're concerned, Sergeant Thabo Musia will still be on the stand for a little while longer.